Good evening, one and everyone. I am CA Samir Ledda, former chairman of Pune branch of ICAI. I welcome today's speaker Anupamaji Agarwal, committee chairman in absentia, CA CV Chitri sir chairman and vice chairman in absentia, and all the August audience for today's webinar organized by Committee on Commercial Laws, Economic Advisory and NPO Cooperative of ICAI. We are delighted to welcome you all in webinar being organized by this committee of ICI. It's indeed my pleasure to be moderator in Know Your Law series number 59, webinar on recent updates in PMLA on 30th May 2024, that is today, being organized by this committee. In a short while, we will start this webinar, and I would like to appraise you about CCLEA and NPO committee. This committee is focusing to encourage chartered accountants to shape strategy and policy that unlocks economic, financial, and social value while combining analytical foresight with commercial acumen. One of the core areas of this committee is to serve the multifunctional tasks of analysis, knowledge dissemination, inputs to regulators on policy formulation, to develop and publish technical guides, background, and to create awareness for professional opportunities for chartered accountants in commercial laws, economic advisory, and NPO cooperatives. Our eminent speakers will talk recent updates in PMLA in this webinar, and we hope that the same shall be useful to members. Welcome Anupamaji on behalf of ICI and all the participants today. Am I audible, Anupamaji, to you?
Yeah. Shall I start?
Before you start, I will like to introduce you to our audience. I actually some issues with my system. I'm not able to start my video, so kindly excuse me for that. It's my indeed pleasure to introduce our speaker, C. Anupamaji, to all the audience. By qualification, she is FCA. She has completed CISA USA, insolvency professionals, certified anti-money laundering specialist. Her professional credentials are certified anti-money laundering specialist, insolvency professional since July 2017, chartered accountant in 1994, many other certificate courses like international taxation, GST, CISA, DISA, etc. Working experience is practicing chartered accountant as a partner in Piyush Agarwal and Company since 1995. Her professional activities are certified anti-money laundering specialist from ACMS USA. ACMS is headquartered in Chicago and also has office in New York, London, Tokyo, Hong Kong, Beijing, India, and Singapore. Deep analysis of 40 recommendations of FATF on combating money laundering and the financing of terrorism and proliferation. Analysis of mutual evaluation report of FATF on India in 2013 and its comparison with 2010 report. Welcome, Anupamaji. Now you can start your session for audience.
Thank you, Mr. Samir, for your warm welcome. Today's topic is on Prevention of Money Laundering Act, which is very closer to my heart, and I'm doing the practice in money laundering from last 5 to 6 years. Today, I will like to cover the update on money laundering, what is the latest provision, what is the latest things happening, and the practical aspects of the PMLA. How the investigation is happening in the Enforcement Directorate, how the investigation authorities are calling the people doing the investigation, and what are the latest changes in the money laundering law, what are the latest and how the persons are facing also the summons and the investigations, I mean, say I'll be covering all the practical aspects. I don't want to consider, I don't want to talk on a law because I feel that everybody knows a law. And law, we all learn, but see what happens, how the happens in money laundering. The first thing is, one we should know is ECIR. What is ECIR? ECIR means Enforcement Case Information Report. It is just like a FIR, which is first information report, normal FIR, which happens in day-to-day civil or criminal cases. So ECIR is a terminology given by the Directorate of Enforcement. And the first thing, whenever a case is started by the Directorate of Information, they make an entry in their register, and this entry is called, or they make a registration of the case, which is called Enforcement Case ECI, Enforcement Case Information Report. How a person is affected by it. Initially, what happens is a summon comes. One page of summon comes to a person under Section 50 of PMLA. Well, how does a summon look like? It is just a two-page summon. Only on one page is a covering letter. And at the top corner of the summon, there is one number is written, which is called the ECIR number. And then the name of the person is written in the summon. And they say that you have been called under Section 50 of the PMLA. And you have to come as you have to come yourself, and you have to give these statements, and those statements has an evidential value. And along with that covering letter, it has one annexure. That annexure contains some details what a person has to carry or what a person has to print. Along with the on the date which is mentioned on the letter. So what happens is, it is a person to whom a summon is issued. That ECI ever given to a person to whom a summon is given. A summon comes, he or she doesn't know what is it all about, on which case he has been called. Only from the annexures, they say that bring your 10 years financial statements, bring your 10 years income tax returns, bring it of yourself, your family members, bring all the bank details, bring all the details of your property and some ledger accounts. From some ledger accounts, you might come to know that this might be a problem area. But otherwise, no one comes to know for what the person has been called for a summon, and where his statements would be recorded on oath, and those statements has an evidentiary value against him, against the person who has been called, and against the other accused also. So when a summon comes, and the ECIR is never given to a person, so it becomes a very, very straight blind game for a person that a summon comes from the Enforcement Directorate, which is one of the most powerful agency in the India, and he doesn't know the person to whom a summon has come, whether this summon has come in the capacity of as a witness, or whether the summon has come in the capacity as an accused. In the other laws, other than the money laundering, if the summon comes, the FIR is given, or if FIR is not given, then we can download the FIR from the website. The FIR number is there, we can download it from the website. Or if that FIR is not uploaded on the website, we can go to a local police station, ask for a report, and or we can go to a magistrate and ask for the FIR. So if the FIR comes to me, then I can prepare my evidences, and then I can prepare my defense according to the FIR. And at least it is in my knowledge that for what I have been called, what is the offense against me, why the investigating agency is asking for this information. But in the case of money laundering, these type of things are not there. So the ECI comes, nobody knows what is there in ECI. Only one ECI number is written, and then an annexure. And then they say that you have to come and you have to give your statement on oath. If you do not come, you will have a penalty, and they will level some penalty. And you have to give your statements on oath, and everybody knows something about the money laundering law, that they have a power to arrest. So everybody is scared of the summon. So a person who receives a summon, he doesn't have any clue why he has been called for. So it becomes very difficult for a person that who has received a summon to prepare his defense. Now, if you ask from the enforcement directorate that please provide us the copy of ECIR, they say they do not have any report. It is there just their internal document, and they do not provide it. So they do not give ECIR to anyone. Earlier, they just do not give. If maybe after some time, but in general, they do not provide the ECIR. So it becomes so difficult for a person to prepare his defense, and he does not understand that they're asking my 10 years paper for what they're asking, what the offense I have been committed, and why I have been caught. So that is the problem which is there in this money laundering law, or which is there in this investigation. And they have such a stringent powers, and the person who has been called for does not have any clue and cannot prepare any defense in advance, that why he has been called for, why they are asking for the information, and whatever statements they are recording, it is recorded on oath, and this they have an evidentiary value. Those statements, even if you retract, retract means whatever statement I had given to an authority, maybe I come later and say, now these statements are wrong, I've been under pressure, and I retract. Nobody gives a damn to the retraction. So even if you retract the statement, that retraction is of no use. So practically, retraction is not there as such. So that is how the investigation starts. That is how the investigation starts by the Directorate of Enforcement. They have complete knowledge of the offense, and a person who has been called for, he doesn't know whether he has been called for as an witness or as an accused, and what is the basic offense, why he has been called for, why are they asking for the information. Now, see, whenever any investigation is, I'll just tell you a bit, what is the difference between the investigation by the enforcement directorate and what is the difference of the normal investigation. When a normal investigation happens, first of all, you get the FCR and you get the FIR. Now, in the normal investigation also, the investigating officer maintains a day diary. In that day diary, the numbers are paginated, means all the numbers are there, like from 1, 2, 3, 4, 5, 6. So if you get a number 8, then you understand that there were 7 pages earlier than that, and then there are other pages next to it. But in the money laundering, whatever case is prepared, they do not number it. It is there in a file, and you punch, they have a punching paper, so they do not number, and the paper can go and paper can come out. So you can never come to know that earlier than you, how many people have been called for by the enforcement directorate relating to this case, and after you, how many people have been called for. Even you cannot, the third person even cannot determine that how many times the statements have been recorded. Whenever in the other offenses, if the statements are recorded of any person, on the top of it, they write that on the statement dated so and so, in continuation of the statements recorded on date so and so, so and so, so and so, so and so, these are the statements. But here in ED, even if you have been called 4 times, 5 times, they will not never write at the top of it. So you will not even So the third person not even will come to know how many times the statements have been recorded. So everything, whatever investigation they do, it is not transparent. The person who has been investigated does not have any clue. He does not know even before him how many persons have been called for. After him, how many persons have been called for, whatever they have said, and whether they have said anything in his favor or against, so that he can prepare, he can give his evidence or prepare his defense accordingly. So nothing like that is there. So that's how even the manner in which the investigation is done by the Directorate of Enforcement in the financial crimes, the case becomes more and more complicated for the accused. So that, first of all, even the act is so stringent. Number two, the way you are conducting the investigation. The third, the person who has been investigated does not have any information. Why he has been investigated, what are the evidence he has to prepare, how guidance he can take, and prepare his defense and give all the documents to the investigation agency or to the directorate so that his case becomes strong and he can come out of it. So these are the real problems of the investigation by the Directorate of Enforcement. Now, what happens is ED. What the ED does, whenever they file a complaint, they use a word RUD. The meaning of RUD is relied upon documents. And there are also unrelied upon documents. Suppose someone has come to me, my statements have been recorded 5 times or 6 times. It is their wish that out of 6 statements, they will attach only 1 statement and they will say that this is the relied upon document. The other 5 statements, which might favor me, they might not even attach them. And they say that that is not a relied upon document. And in my statements, it is not even written that how many times my statement has been recorded. So it becomes too much difficult for the person to know what has happened. And even I do not know that other persons who have been called for, whose statements have been recorded, whether they have spoken in my favor or against me. So the investigation agency, the enforcement directorate, only give those documents. They do not give 100% documents. They only give relied upon documents. The documents which are not relied upon, which might favor to the person against whom an investigation has been carried out, they will not get. So the things become more worst to the accused. So that is how the investigation is done by the Directorate of Enforcement. Now, you have Section 71 under PMLA. Section 71 of PMLA says that other laws will be binding unless and until they are contrary to the laws, whatever has already been provided in PMLA. But this Section 71 is never been followed by the authorities. PMLA has provided the law for search, seizures, arrest, but for investigation, no procedure has been prescribed in PMLA. So what does that mean? That means if no procedure has been defined, then that means they have to follow the procedure of Code of Criminal Procedure, CRPC. Whatever procedure is there in CRPC, as per Section 71, if it is not contrary to the PMLA provisions, at least follow that procedure. But they are not following it. They do not follow any of the procedures prescribed. Under CRPC, it is written that an investigation officer has to maintain a diary. Diary has to be paginated. Page numbers are there. You should, the FIR should be provided. Person should know that whether he has been called as an accused or as a witness. So those things are never followed. Neither they have prepared any manual kind of thing or has uploaded that on the portal. So that is how they're doing an investigation. So no procedure is followed. Whatever they do it under their own thing and makes the thing more complicated for the persons who are being investigated. They have, we have very stringent laws also. We have TADA, which has been replaced by Prevention of Terrorist Act. Now, those provisions have strict conditions. We agree that under those laws, maybe those strict conditions are there. But those bail conditions has been borrowed from those acts, which I feel that this is unjustified as far as PMLA is concerned. Now, how the investigation is carried out in PMLA? There is no time limit for investigation. Their investigation can continue for years together. You do not know. You will never come to know whether you will get one sum, and after sometimes you will, after 1 year you will get another sum. You will never come to know whether the investigation has been closed. They do not have the authority people. They do not have any timeline for investigation. Only in one case they have a timeline. That is, if they arrest a person, then they have to file a complaint within a period of 60 days. Otherwise, on 61st day, that person would be entitled for a default. Whatever I've seen, it has never happened in the history of ED that they have not filed the complaint within a period of 60 days. They file the complaint even if it is incomplete, so that a person who has been arrested does not get entitled for the bail. So they file it. Now, they do not have any timeline for investigation. Suppose they have arrested a person. Within a 60 days, they have filed a complaint relating to the investigation done for that person. Now, suppose there are some other persons who are also involved in that crime or in that investigation. What happened is, after that, they will do the investigation of that person. Bail is not there. Bail provisions are very strict. Person do not get a bail. So now, for the second person, they will do the investigation. If they're arresting that also, so again, within 60 days, they will file a complaint against that person. So they are filing the report complaint partially. And they have a provision that they can file a supplementary report. So their investigation duration becomes too long. Their investigation goes on for years together. And if there is a provision in the PMLA law that if you have done an investigation for a person and if you do not find that that person is an accused, please give him the closure report. But practically, I've seen in never, not even a single case, they have issued a closure report to the person. So, like in income tax, we are a chartered accountant, so in income tax, we see that we get the assessment order. Then if we get the assessment order, we know that the case is closed, the matter is over. But here you never get a closure report. So the person who has been investigated does not know his status. He just prays to the God that if further summons are not coming, that the matter is closed. So this investigation, whatever they do not have any timeline. This investigation can continue for years together. And in general, if they are not arrested a person, their investigation takes years. Now, when the statements are recorded, how statements are recorded? Suppose a summon has come, the date is given, time is given, the office is given, along with the annexure that you have to bring all these documents. Person who has been investigated doesn't have any clue why he has been called for. He goes to the directorate he goes to the department. take all the papers with him or do not take. How the statements have been recorded. See there, I'm sharing you some very practical aspects how the investigation is being done. What happens is they'll call the person in the morning. Till evening, they will not talk to him or her. And the person gets dead scared. And he gets mentally exhausted that what is happening with him. He cannot go out from there, but he is mentally exhausted. And he gets so exhausted that he wants to go out of it. And it comes to his mind that whatever statements you want to record, and please make me, I just want to get out of this office. Or the person who is being called for, they he knows he has a fear that the ED people has a power to arrest. So he's otherwise also very scared. And then generally the information what they ask for is they even ask for his family members' details also. They ask for the details of his wife also, 10 years returns, 10 years returns of their parents. So a person becomes very scared. And he just wants to go out of from the enforcement directorate office and says, whatever you want to get signed, please, I'm signing it. Whatever you want to say, and I want to. So that is how all this investigation is happening there. Suppose we all, how I'll just give you a brief background of the money laundering law also. What is the law? There is one scheduled law. There is an offense. There is a predicate offense. One predicate offense is committed. Now, in that predicate offense, if some money is generated and you are in the possession, acquisition, concealment, or use, or projecting that money as belongs to you are in possession of that money, then ED comes into a picture. What does that mean? That means is suppose a murder happens, right? Now, due to that murder, a person gets, suppose, 10 lakh of rupees. Now that 10 lakh of rupee has got due to a murder. Now, even if he doesn't do anything with this 10 lakh of rupees, that money has come to me. He just keeps that money in his pocket. And since he has not done anything else other than that 10 lakh, other than the offense, or other than, let's not talk for murder. He has done some cheating and got 10 lakh rupees. Now he has done a cheating and he has come with that 10 lakh rupees in his pocket and came to his home and he's keeping. The money laundering will come into picture the moment any money is involved. Earlier, what the concept was that if you convert the proceeds of crime, if you try to convert the proceeds of crime into white, then only the money laundering provision would be attractive. But there was an amendment in the PMLA, in the Money Laundering Act, and that amendment had a far-reaching effect. And they said that there is no need for a conversion. Even if you acquire it, you possess it, you use it, you conceal it, whatever is there, the money has come to you in any fashion, or you are just keeping it as you're just keeping it as a friend or as of someone. Even if you're keeping it, you do not know that this money has come from some criminal offense. The money laundering offense has been created. So, due to amendments in the money laundering law, the offense which was there simply for layering, integration, or placement has been changed that if any money is involved into any of the offense, which the list of those offenses are attached in the schedule of PMLA, then if a person has done any of those offenses and money is generated out of it, then ED will come into a picture. So practically what happens? The things what are happening is a person is facing one prosecution is already facing another main crime. The another prosecution he face it under a PMLA, and under the PMLA, two proceedings are taking place. One proceeding is for the one are the attachment proceedings. They are called as civil proceedings. Whatever property you have taken, a government can, the ET can attach that property and confiscate it. And dusra is the prosecution. You would be punished for 3 years to 7 years of 10 years for that offense. For committing an offense under Section 3, and that punishment is prescribed under Section 4. So that means, and one offense is created, and a person is liable for 3 prosecutions. One of the original offense. Number 2, prosecution criminal offense under money laundering. Number 3, the civil action under money laundering. First is the original punishment. Second is the prosecution under Section 4 of PMLA. Third is the attachment proceedings done by the adjudicating authority. So that is how this provision, the money laundering comes. And the worst part is that under the money laundering law, you do not get a bail. Suppose it's very difficult to get a bail because of the twin conditions attached under Section 45 of the PMLA. Suppose a person has done a cheating in IPC Section 420. Under IPC, he is entitled for a bail. But under money laundering, if you are charged under Section 3 and you have generated some money out of the cheating, you will not get a bail here. So even if in the original offense you have a right to a bail, but under money laundering for the same offense for which you have generated some money, you will not get a bail. So that's how it makes the money laundering provisions more and more draconian. Whenever they are calling for an investigation, whatever is the main offense, on the main offense, they ask some documents, many documents they ask of your family members. What the ED does is that they do not restrict their investigation to that event only, to the main offense. They even go to other things, whatever documents have been asked for. So that is more worrisome. And they bring out some more offenses on the statement, on the documents, whatever they have been asked for. So they do not restrict themselves to the predicate offense only or to a scheduled offense. They're asking for many other informations and doing many other investigation of the person to whom they have called on a summons. Now the person to whose statements have been recorded, I think it should be a legal right of that person. Whatever statements, at least you're recording for me. Please provide me my answers along with the questions, whatever you have asked for. They are not providing. They are not providing even a state. They are asking the accused or a person who has been summoned to sign everything, but they do not provide. Now, whatever question is there, it's a long questions, long day. 10 pages of statements have been recorded. The person when comes out of the ED's office, he's so exhausted. He does not remember that what has been asked for and what answers are given. So it's very difficult for him to make his defense. Now, now some guidelines have come that statements have to be recorded in a video camera, but there is no audio allowed. So in the video camera, it is very difficult to determine that whether the investigating officer is recording normally or is giving an undue pressure on the person for whose the statement have been recorded. See, a person, investigation officer, can smile and still use the strict words. By smiling, he can say that if you will not admit, then I will arrest your wife. I'll call your kids, and he's just smiling. So from the video, it will not be possible to know that the person whose statement has been recorded, or whether some pressure was given to him or not. They do not allow the legal counsel or a chartered accountant. Now they have started allowing it. So if the chartered accountant can see it from the other side, but he is not allowed to listen. So the investigation which is done by the Enforcement Directorate is not fair. A person who has been called for, first of all, he doesn't know why he has been called for. They're asking so many other personal information. No details are there. And then they're not restricting their investigation only to that person. They are also going beyond. So that is how the investigation is being done by the Enforcement Directorate. Now, ED in general might say that you're not cooperating. Under Article 20 of Constitution of India, you have a right to be, you have a right against self-incrimination. You are not supposed to provide any evidence against which you yourself can be incriminated. Now, ED might say that you are not cooperating. If you are not cooperating, then the bail will not be given under Section 45. Bail provisions are really very stringent. So in general, what we have seen is that in the complaint, if it is written that the person is not cooperating, then it becomes very difficult for him to get a bail. But now there are some Supreme Court judgments which say that non-cooperation will not lead to denial of bail because a person has under Article 20 of Constitution of India, it is his fundamental right to not to give any evidence for against self-incrimination. So that's how I have already said that the one amendment has come under Section 3. According to Section 3 amendment, earlier there was a difference between a scheduled offense and the money laundering, because earlier, whatever they have said, whatever money has been generated out of the proceeds of crime, and if from that proceeds of crime, if a person project it as a untainted property, that tainted property is projected or claimed as an untainted, then only money laundering would be affected. But now that and has been replaced with or after the Supreme Court judgment on 27 July 2022 of Vijay Madan Lal Chaudhary, which was given by three-judge bench judgment. Justice Kanvilkar was there. So after the amendment, the distinction between the predicate offense, between the scheduled offense and the money laundering offense has been eliminated. So the moment a scheduled offense has been committed and some money is generated out of it, then a person will be prosecuted against under the original offense also for the under the money laundering and law also, and under money laundering he will face two proceedings. One is civil, that is the attachment of the proceeds of crime, and another is the prosecution. See how this, I'll tell you, money laundering law has been amended many times. But the strange part is that it is such a stringent law. And this law was amended through a money bill or a finance bill. What do you mean by a money bill or a finance bill? Means if the money bill is to be approved, it doesn't go to a Rajya Sabha. So that means it only gets approved in Lok Sabha. So most of the major amendments have come in the money laundering law only in money bill, through a money bill. Even the 500-page judgment which was held of Vijay Madan Lal Chaudhary on 22nd July 2022. Sorry, 27th July 2020. When they were given a judgment, they have said that they know that all these amendments in money laundering law has come through money bill. That matter has already been referred to Roger Matthew case where a 11 bench would sit and decide about it. Despite they know that all the amendments have come through a money bill, still they are giving their judgments on the basis of the arguments made by both the sides. So all the amendments in law has happened through money bill. Maybe it is in the government, maybe in the Rajya Sabha, the government who has brought the changes, they were not having a majority in Rajya Sabha. That is why they have not, you know, uh, they made the amendments like this that it doesn't go to a Rajya Sabha. That might be a reason. Otherwise, there is no other reason that all the amendments in money laundering law has come. Major amendments in money laundering law has come through a money bill. Yeah, I'll tell you about bail. Bail in money laundering. Section 45. Section 45 of money laundering law says that court will not give the bail unless and until the court is satisfied that there are twin conditions. That one condition is the person is not guilty of the offense, number one. Number two, that he will not even commit the offense in future. It becomes very difficult at the time of bail to satisfy the court that a person is not guilty of the offense. In the case only then they get a copy of complaint at the time of a bail application, but where they do not have enough, they just have a complaint, but they do not have details of all the documents, all the statements recorded, all the ECIR, all the informations are not there. But on the basis of complaint, becomes very difficult. And even the lower courts, they are not giving any bail. Even the high courts are not giving a bail. The Supreme Court, which is basically a appellate law authority, has become a bail. Now all the bails are going to the Supreme Court. So most of the applications for bails are heard by Supreme Court. Now the Supreme Court has to intervene and pass some amendment under the PMLA or under any other laws so that the bails should be given by the lower courts. Otherwise, the bail application, you go to any court now, in the afternoon, most of the courts, because the judge has to be convinced that a person is not guilty of an offense. That means a lot of counsels are there who are explaining all the complaints to the judge. So after lunch, major even in the district courts, special courts, high courts, most of the time the long hearings are there and in which the bail applications are being discussed, are decided. See, this money laundering law, this law, the Act is Prevention of Money Laundering Law 2000. It was the assent of the president was given in 2003. It was notified in 2005. Now, under Section 3, money laundering is a continuing offense. What do you mean by a continuing offense? Suppose the offense was committed before the money laundering law has come, and a person is still enjoying the proceeds of crime, then he can be penalized or prosecuted under money laundering law, even for the offense which was committed before the law has come into operation. I'll give an example of it. For example, suppose the offense was committed in the year 1990, right? After committing the offense, the money is generated out of the offense. After the offense, the person has built a house from that money, right? Now that house is there, he's enjoying that house. Now in 2008 or 13, ED had come to know about the offense which was created and done in 1990. And they had some, this thing that a person is still enjoying that property or the house has been created out of. They can do an investigation and PMLA and the PMLA can be levied on him and keep the offense which was, that means it is a continuing offense. They say that if any property or if any proceeds is generated or a proceeds of crime are generated from the scheduled offense and you are still enjoying those proceeds of crime, then any day after this law has come into operation or after the day when that offense was added in the scheduled offense, in the schedule annexed to the PMLA Act, then the PMLA proceedings can happen on that person. Now, suppose I'll give you one more example. Suppose a person has done a crime and earned a crore of it, and that crore of rupee got finished by any reason, in the sense that somebody has taken it or it was burnt or something was there, or that house. Let's take an example. In 1990, whatever the offense was committed, he built a house, he was staying. Suppose that he built a house and that house got burnt and that land also was sold. So that means now nothing is there. Even then, if the offense was committed and a person has generated some money out of it, then PMLA proceedings can take place. Suppose, and there's one more case, suppose an offense is created in the year 2013, right? And then, and money is generated out of it. But they had some ancestral house which was earlier than of 2013 or before before this money laundering law has come into operation. He's got it from his father or great grandfather, whatever. Then they say that since a money was generated from a scheduled offense and you have generated a crore of rupees that time, even if this property is your ancestral property, they are doing the attachment because Under the proceeds of crime, under section 2, the proceeds of crime has been defined like that. That value of the if any money is generated, then they can attach any property of equivalent to that value. They say that you had generated a crore of rupee from from the scheduled offense. Now you have, even though you have an ancestral house, or even if you have a house from your legitimate money and which you had purchased 20 years back before the offense has committed, they are even attaching those houses. They say, no, you have generated a crore of rupee, they will attach a property of worth a crore. And please remind it, what is the valuation they are taking? The house, suppose, if I take a house, how do I value the house? They are not taking today's market value. They are taking the value of the house on the date on which the offense was committed. Suppose the house was there. Now today's its value of 5 crores, but the house was purchased 20 years back. That time it was 5 lakh of rupees. On the day the offense was created, the fair market value is 10 lakh of rupees. So they say that even if you had generated a crore of rupees, that house today has a value of 5 crore. They say that they will take its value to be 10 lakh, not the 5 crore. So that means they will attach any other property of more than 90 lakhs also. That is how the attachments are being done there. You know, Section 120B, it is a scheduled offense. Section 120B talks of the criminal conspiracy in IPC. Now, conspiracy is a thing which can never be proved. So, if a conspiracy cannot be proved, and in a statement, some person has taken a name of some other person, so they can say that there was a conspiracy between the two. But how will you prove the conspiracy? Conspiracy can only be proved at the time of trial. And on the basis of the alleged offense, they have even arrested that person who has conspired. And but that conspiracy, whether there was a conspiracy or not, can only be proved after a trial, and you are not giving a bail. So, in any offense, conspiracy is the thing which can always happen. And even under PMLA also, there is a section called Section 23 that is related to an interconnected transaction. Now, interconnected transactions means, suppose proceeds of crime have been generated. Now, out of those proceeds of crime, the proceeds was generated in 2013, suppose. Now, that money has come to a person in 2018, and some person has done a genuine sale or purchase, but the person who has paid the money is that proceed of crime. But the person to whom money was paid, he has supplied some goods. They say that this is the money, this was the proceeds of crime, which has flown to that person. So all these transactions are interconnected. So the person who has received that money, they say that you are also liable. You would also be made an accused under the money laundering. So that is how these things are happening. In today, if you say that around 1100 cases are going on in ED, I think only in 25 cases, the trial has started. Otherwise, most of the cases, the trial has not even been started, and the persons are facing. A person are facing too much. I mean to say, there is the properties are being attacked. A lot of damages have been done to those, and the trials have only out of 1100 cases. The trial has only started for 25 cases. So you can look at the percentage. If I say 25 divided by 1100, so it is not even 2%. That is how it is happening. uh, in general. And there is a major judgment of Vijay Madan Lal Chaudhary. Now, Vijay Madan Lal Chaudhary says that money laundering law is neither it is a penal law as well as it is a civil law. Why? Or it is a regulatory law. Why? Because it is also preventing the money. Since it is a combination of a criminal law as well as of a regulatory law, so the entire criminal jurisprudence, whatever has been developed till date in criminal laws, has been inverted. Means that proof of innocence, it has been inverted. The moment you have been made an accused under money laundering law, it is your duty to prove that you are an innocent, you are not accused. That means otherwise there was an assumption of innocence under other criminal. Since it is a special law, it is a combination of a regulatory law as well as of a criminal law. So that is why the entire criminal jurisprudence has been inverted. Uh, the inversions is that proof of innocence, burden of proof. Otherwise, you have to prove that you are not guilty. Otherwise, the investigation agency had to prove that you had done a guilt. But now they say that the section has been levied on you, the charges have been levied, you have to prove that you are not a guilty of this offense. So there's an inversion on the innocence, there's an inversion of the burden of proof, and the bail provisions have been made more stringent. So this money laundering law, which is a unique law, has inverted the total criminal jurisprudence. And this Vijay Madan Lal Chaudhary has upholded that these provisions are right and given a judgment state, stating that this law is there in its place. And rather, this judgment has made this law more powerful. This judgment was delivered on 27th July 2022. Then on 25th August 2022, in Karti Chidambaram versus Directorate of Enforcement, a review petition was made for this judgment, which was accepted on the two grounds. The one ground was that the ECI report, which was not given to the accused, because Vijay Madan Lal Chaudhary had said that ECI report is their internal document and there is no need to give the ECI report to the accused. Now, in the review petition, they said that they will review this judgment on the two things. One, handing over the ECI report to the accused, number one. Number two, reversal of burden of proof. That so on those two matters, they will review it from 25th August 2022 till date. That is almost 2 years. No bench was now the proceedings will take place on 25th to 27th July 2024 as per the latest. The three new judges have been constituted by by Chief Justice Chandrachud, and now benches have now judge bench has been made, constituted, and they will listen on 25th, 26th, 27th of July 2024, and the stake of this law, the stake of the judgment, which has made money laundering law more draconian, will be seen whether this judgment was right or not. But basically, if the how will it happen? That time will tell. But basically, they will review on the two grounds whether the ECI report should be given to the accused, number one. Number two is this reverse burden of proof, or that the person who has been made guilty has to prove that he is not a guilty. Let's see how this happens. Now, one thing more. Under Section 90 of the PMLA Act, they have a power to arrest. What do you mean by that? Power to arrest means that by giving the reasons to be recorded, by communicating the reasons to the accused, they can arrest a person under Section 90 of the PMLA. Even in Vijay Madan Lal Chaudhary, this point was discussed. Now, Vijay Madan Lal Chaudhary has never mentioned, neither in the law it is written, what will be the mode of communication, whether it will be oral or written, nor the Vijay Madan Lal Chaudhary has touched upon it. So there was, after this Vijay Madan Lal Chaudhary, the judgment came, Supreme Court judgment, and in Pankaj Bansal case, which says that before arresting a person, you have to give a reasons in writing to the person to whom you are arresting, right? So Pankaj Bansal case came. Then another Supreme Court judge case came. Its name was Ram Kishore Arora. In that judgment, it was said that even if you tell orally to a person that you have been arrested on these grounds, it is sufficient, provided you give him the reasons within 24 hours in writing. So that means a person would be arrested and then only the reasons would be given. Since Ramkishore Arora is a later judgment, provided this judgment would prevail over Pankaj Bansal judgment. So again, the problem is still that if you want to arrest it, you just tell him orally that you are being arrested on the basis of this, and then arrest him, and then record the reasons in writing and give it to him. Now there is one more judgment which has come now in the month of May 2024. This judgment is of Tarsem Lal versus Directorate of Enforcement. This judgment is a very new judgment, and which has tried to make a bail provisions which are very difficult and which are very stringent in Section 45 of PMLA. This judgment says, what this judgment says is, this says that if a complaint has been filed by the Directorate of Enforcement to a special court and a cognizance of that complaint has been taken by the court, then ED will not have power to arrest. It is a very, very welcoming judgment. That means if ED still want to arrest a person for whom the cognizance has been done, for a complaint has been done by a special court, then we have to take a permission from the special court for arresting that person. In the judgment, it is also said that if they want to do an investigation of the person who has not been made accused in the complaint, then they still have a power to arrest. But if a person has been made an accused, then the moment a cognizance has been taken by by the special court, then they loses the power to arrest that person. Number two, which is very also welcoming effect, which has been taken care of by the judgment. Whatever was happening is the complaint was filed by the ED in special court. Now the special court was calling the persons, and they were issuing a warrant, initially bailable and then non-bailable warrant. And then they said that the bail provisions are affected, and then they were not giving a bail. So this judgment has even taken care of that part. They said the moment the complaint is filed, then the court will not issue a warrant. They will issue a summon. And when they issue a summon, and a person who has been made an accused come before a court for a summon, then they will, then the court will ask for a bail bond from them, and this will not be considered as a bail, and the bail provisions under section 45 would not be granted. So that means the person who has been made, all the persons who have been made accused, they will go to they will appear in front of the court on the summoning, and they will furnish a bond, and the bail provision under section 45 will not be applied. So probably the Supreme Court has given a way that all the persons who were facing the law, that the moment they are called for, they, even if the investigating authority has not arrested them, they were asking the court to put them behind the bars even though investigation was completed. So they have made a standstill to those provisions, and now the court comes. So the persons who have been made accused, they do not have to run around, or do not have to go for a bail. The bail is actually automatically granted, provided, but and they are furnishing a bond. On the bond, they take a passport, so a person cannot flee from the country. They take some FD, they take some undertaking that you will cooperate and you will appear whenever you have been asked for. So on the basis of that undertaking, they are giving it. And this is the latest judgment of Darsimla versus Directorate of Enforcement. I think it came in the month of May, in this month itself. And so that has given a bit relief to the bail provisions where a person has been wrongly stuck up. And we are just waiting that on the date which I've said, that review petition of Vijay Madan Lal Chaudhary, which will be happening on 25th to 27th July, I suppose. On those days, let's see that the bench sits and the arguments held and the reservation is given. And we have a full hope that under the Justice Chandrachurji, justice would come, and the money laundering law, which has been made so much draconian, some power would be curtailed, and the investigations and the persons would be given some relief, and the law would be made less draconian, and some powers of the authorities should be curtailed. So with this, whatever I wanted to say relating to the latest updates on the PMLA, I have included, and I never wanted to discuss the original provisions and see. I just wanted to tell you the practical aspects of money laundering, how the summoning is being done, how the investigation is being done, and a journey from a summon till filing of the complaint is a very important journey. And a person who receives a summon, I fully advise them, take advice from the chartered accountants or from the councils who are doing a practice into it, so that they get some idea, and their name either gets dropped in the complaint, or even if it's not dropped, the case is so mild that they will be able to win in the court. Yeah. Mrs. Sameer, with this, if there are any questions, I can take that. Mrs. Samir, are you there? I can take the questions.
Yes, yes. I'm there, ma'am. Uh, we have only one question so far.
Yeah,
Uh, do you think such a strict provision under PMLA are justifiable?
they are not at all justifiable. These
Uh,
strict provisions should not be there. That is why even Vijay Madan Lal Chaudhary decision, which has happened, which has made the law more stringent, the review petition was accepted by the court, and CBI judgment was initially held in August 23. Now again, it has been the bench has been made, and probably the hearing would happen on 23rd to 25th to 27th July, and probably the cases would be made less draconian. And I think there is some political agenda also against these making such laws, because if you see the history, only from the opposition parties, more prosecutions are being held, more investigations are there. Ruling parties might be there might be less investigations are there. Probably that might be there or not. I don't want to comment upon that. But these draconian provisions should not have been there.
well, thank you, madam. Actually, there is no question from audience so far, except this question. Uh, all the members, we are sometimes there was technical issue today in session. We have received complaint from some audience. We are extremely apologize for that. I sincerely thanks Anupama madam for sharing wonderful knowledge with the audience. We see your association in future also, madam. Thanks a lot again on behalf of ICA and participants.
Thank you. Thanks a lot.